Okay, folks, let's take our seats, please. Okay, can I have your attention, please? Thank you, that was quite quick. Okay, we're now moving on to our final keynote address of the day, and I'm absolutely delighted that it's Professor Julia Sloth-Nielsen, who is marked in the programme as the University of the Western Cape, but obviously has a lot of different titles to her name. Let me give you an introduction. Professor Julia Sloth-Nielsen teaches children's rights, international family law, and child justice. She was a member of the project committee of the South African Law Commission, which drafted the Child Justice Act 75 of 2007 and the Children's Act 38 of 2005. She was elected to the African Committee of Experts on the Rights and Welfare of the Child in January 2011, and in November 2012 she was elected second vice chair. She has published Children's Rights in African Context, a Legal Analysis, and consulted widely to governments in Eastern and Southern Africa undertaking law reform with respect to children's rights. She boasts more than 100 accredited articles and book chapters. So we are extremely honoured to have Professor Julia Sloth-Nielsen close our day today. Thank you.
Thank you very much to Corinne and to the organisers for giving the African Committee of Experts a platform to engage with the safeguarding precepts and principles. Now, the first part of my paper commences with a basic introduction to this child safeguarding movement, and here I have to confess that I relied extremely heavily on the website Keeping Children Safe to find out everything that I thought I needed to know about safeguarding. And to this end, you'll have to forgive me if I make mistakes, but please do correct me so that I don't continue under any misbelief as to what safeguarding entails. So that was necessary for me to do so that I could then turn to the second part of my paper, which is an elaboration of what I believe are the relevant substantive provisions of the African Charter on the Rights and Welfare of the Child and their relevance to the safeguarding movement. And then in the second part of that second section, I talk a bit about the role of the African Committee of Experts on the Rights and Welfare of the Child, which is the body that's in charge of implementing monitoring the implementation of the Charter. And I talk about the mandate of the committee in particular. The next section talks a bit more about the state party reporting mechanisms. As with other international treaties, the primary obligation that is incurred by states who ratify the Charter are to provide initial and thereafter periodic reports. And then I talk about some everyday practice elements of the committee's work, which I think might be relevant to safeguarding. And then in the final section, I look at the committee's interface with the NGO movement. So you can stop me if this becomes too technical or academic. So the first part of my paper starts then with child safeguarding, which I understand as the responsibility that civil society organizations and aid and development and humanitarian organizations have to do no harm, i.e. not to expose children to the risk of harm and abuse, and that any concerns they have about children's safety within communities are reported to the appropriate authorities where this is appropriate. This comes out of the realization that development agencies, relief workers, humanitarian organizations and the like, many of whom do not have children as their primary focus or mandate can become involved in the abuse of children or become aware of it occurring during the course of their work. I myself recall being in South Sudan in 2005 and having a heated discussion, maybe discussion is too polite a word, with the driver who was married to a 14-year-old. Child safeguarding, in my view, centers very much around local level implementation and around the 4 principles of development of policy, of people-related procedures, for instance, in relation to expectations for staff, associates, volunteers, and child-sensitive recruitment processes. Procedures for implementing child safeguarding procedures that are applied across the organization, including steps to be taken when an incident of abuse or the risk of abuse is reported, and then accountability of member organizations to monitor and review their safeguarding measures, as has been described in some of the sessions that I attended earlier today. All actions regarding child safeguarding are taken in the best interests of the child, which are paramount, so that the child's best interests determine the response to complaints received. On the slide in front of you, you'll see also that the question of responses to reports of child abuse and the follow-up to complaints, I believe, is a joint duty of civil society organizations and governments. And I come back to explaining this understanding later in the paper, because it affects the interplay between the safeguarding movement and the Committee of Experts on the Rights and Welfare of the Child. So section 2 then starts to engage with the substantive provisions of the African Charter on the Rights and Welfare of the Child, starting with Article 16, which is headed Protection Against Child Abuse and Torture. I suggest that Article 16 sets a high bar in requiring states parties to take specific legislative, administrative, social, and educational measures to protect children from all forms of torture, inhuman or degrading treatment, and especially physical or mental injury or abuse, neglect, or maltreatment, including sexual abuse, and this applies to those who have the care of the child, so it applies in all settings. There are differences in this formulation by comparison to the equivalent article in the Convention on the Rights of the Child, Article 19, but I suggest that the differences are not very material. What Article 16 of the Charter adds is the well-known prohibition on torture, inhuman, or degrading treatment, which words do not appear in Article 19 of the CRC. However, if one looks at CRC General Comment number 13 on violence against children, now Sonia spoke earlier today about General Comment number 8, which is specific to corporal punishment. More generally, the CRC General Comment number 13 is the one dealing with violence against children. And if one reads that through carefully, one will see that there are many references to inhuman treatment and to degrading treatment in that general comment. So it's clear that violence is not something that can be easily defined or pigeonholed. In fact, the CRC general comment clarifies that the concept is not capable of being exhaustively determined, but yet they use the same terminology as is apparent in the Charter. 16.2, the second part of that article, is almost exactly the same as Article 19.2 of the Convention on the Rights of the Child, and it provides for the implementation mechanism. It requires protective measures to include procedures for the establishment of special monitoring units to provide the necessary support for the child and for those who have care of the child, as well as other forms of prevention, identification, reporting, referral, investigation, treatment, and follow-up of instances of child abuse and neglect, in more or less exactly the same words as the CRC. I also refer to Article 15 of the Charter. Article 15 is headed Child Labour and protects the child against all forms of economic exploitation and from performing any work that is likely to be hazardous or to interfere with the child's physical, mental, spiritual, moral or social development. Now, I'm not suggesting that organizations that have subscribed to safeguarding would directly employ children as a worst form of child labor. But, on the other hand, the phenomenon of young housemaids and girls in domestic work, and sometimes boys, is ubiquitous in some regions and contexts, and it's hidden from public scrutiny because it occurs at a household level. Last year, there were reports in the press of South African diplomats who were employing in foreign countries domestic workers under conditions which were tantamount to slavery. So it is hoped also that member organizations require that their employees, volunteers, and associates sign up to the international standards in regard to the employment of child domestic workers, and that the commitments of these employees are also monitored for compliance. Similarly, there's been talk today about harmful cultural practices in the session that I just attended. Article 21 of the Charter provides comprehensive protection against harmful social and cultural practices which affect the welfare, dignity, normal growth and development of the child. In particular, those practices which are prejudicial to the health of the child and those which discriminate on the basis of sex or other status. I argue that there's growing normative consensus internationally, as well as in Africa and particularly at the AU level, on at least the most egregious forms of harmful cultural practice such as FGM, early marriage, killing of children with disabilities, or those accused of witchcraft. The question arises within the context of the very varied contexts within which organizations such as yours work, how you police associates, employees, and volunteers for compliance with Article 21 of the Charter. For instance, is taking a child bride forbidden? The example I just gave earlier. What would the consequences be of associates allowing FGM to be performed on their daughters? The question where the line is drawn on remedial action is not always evident. Article 27 of the Charter is also useful. It provides for protection against sexual exploitation and sexual abuse. Thank you. And I also felt that Article 22, which is the article dealing with children in an armed conflict, could be relevant in some situations. Article 22 is a much higher standard than the equivalent provision of the United Nations Convention on the Rights of the Child. In addition to prohibiting the recruitment of all children aged below the age of 18, whereas the CRC sets the bar at 15, this is recruitment into the state armed forces. Article 22 also requires states to ensure that they take all necessary measures to ensure that no child takes part in hostilities. This provision also applies to internal armed conflicts and strife and suggests a level of responsibility towards children who are not associated with state armed forces. This provision could therefore have a bearing on civil society and humanitarian organizations who are in contact with rebel groups, factions, and gangs. Turning now to the mandate of the committee, it has been widely recorded that the mandate of the African Committee of Experts is expansive. It is obviously premised on the state reporting procedure in the first instance, and to this end, it must be noted that there has been a dramatic increase in state parties reporting to our committee, such that we have to have an extraordinary session in October to make sure that we don't go into backlog mode. As matters stand at the moment, we have 47 state parties to the Charter out of a possible 54 member states of the African Union. We could have had another ratification of a country that thinks that it has ratified the Charter, but they sent an email, and unfortunately you can't ratify a Charter by email. You have to do something a little bit more formal than that. So we're working on that. But we do have a campaign for universal ratification, which we launched in January, and we have it on good news that we are probably going to be successful in having full ratification by all the member states of the African Union by November 2015, by which time the Charter will be 25 years old. When I was in South Sudan 3 weeks ago, we had a commitment that the ratification process, which we have now explained to South Sudan, who had a different idea about it, not the email idea, a different idea, that there will now be support from the AU to assist South Sudan to ratify the Charter by the end of the year. We have 13 reports at the moment under consideration, awaiting finalization, including, of course, South Africa's report. South Africa will be presenting at our next session. Mozambique, I know there are people here from Mozambique. Algeria, I don't think there's anybody here from Algeria, and that's all I can really remember at the moment. But as I say, we have 13 reports under consideration. Additionally to this, the consideration of reports, the committee has a broad mandate prescribed by Article 42 to generally promote and protect the rights of the child enshrined in the Charter, to collect information, to commission interdisciplinary assessments of the situation of children in Africa, to organize meetings on child rights, to encourage national and local institutions concerned with the rights of the child, as well as to give its views on child rights and to make recommendations to governments. That is the so-called promotional mandate. Then the committee is also empowered in terms of its investigative mandate to investigate any matter which falls within the ambit of the Charter, may request from any state party information, and resort to any method of investigating the measures the state party has adopted. The committee is also empowered to formulate and lay down rules aimed at protecting the rights of children in Africa and to cooperate with other African international and regional institutions. As regards the mandate to that empowers us to formulate and lay down rules, we take the opportunity now to thank the conference organizers for allowing us to use this event to launch tomorrow evening General Comment Number 1 on the children of imprisoned caregivers, which is our first formal endeavor to lay down rules and guidance for state parties in relation to Article 30 of the Charter. Then the African Committee of Experts has the mandate to receive communications. Essentially, a communication would involve any matter covered by the Charter, any violation of rights covered by the Charter. And we have thus far received 3 communications. The first one was a communication against the government of Kenya in relation to the rights of children born of Nubian descent who had been living in Kenya without a legal status for more than 60 years, obviously successive generations. And the finding on that is available on the website that I've put up there. The second communication was brought against the government of Uganda concerning the period 2002 to 2005, where the complaint was that the Ugandan People's Defence Force had recruited and used child soldiers in the war in northern Uganda. That the decision was found against the government of Uganda, and the full text of the report is not yet available, but will be so shortly. And the third communication is being finalized at the moment. This is a power that the CRC committee in Geneva has not yet had until February this year, when the 10th state party ratified the third optional protocol to the CRC, bringing up the possibility of communications at the global level. Now, I have to emphasize the point that the primary duty bearers under the Charter are the state parties that have ratified the Charter. That doesn't say there isn't a role for NGOs, but the primary duty bearers are governments which are responsible to ensure that their programs, policies, and laws meet the standards contained in the Charter. And I'll come back to that in a minute. So I'm turned now to subsidiary mechanisms. And I start with the guidelines on the form and content of periodic reports, which we developed and adopted in March, our meeting in March of 2014. The guidelines on the form and content of periodic reports tell the state parties what they need to include in their reports. So in relation to the Charter articles that I discussed a short while ago, the first set of guidelines require very little from state parties actually in relation to child abuse and neglect. They require the state party simply to provide information on the legislative, administrative, social, and educational measures taken to protect children from all forms of torture, inhuman, or degrading treatment. And in addition, to indicate whether the state party has outlawed corporal punishment in all settings. Also, the state party must indicate whether it has established special monitoring units to provide the necessary support for children and for those who have care of the child. I'm not quite sure what special monitoring units means in the context of the Charter, but I suspect that it deals with specialized police units that deal with women and children related issues. With regard to harmful traditional practices, the guidelines require quite a lot more. The nature and type and prevalence must be provided. Measures taken to discourage and eliminate harmful social and cultural practices. Where applicable, measures taken to, this is very specific, to specifically protect children with albinism from violence. State parties must indicate whether child marriage and the betrothal of girls and boys is prohibited under law, and whether the state party has taken effective action to specify a minimum age of marriage of 18 and made marriages registration compulsory. With relation to sexual exploitation, the state party should provide relevant and updated measures, information on measures to protect the child from sexual exploitation and abuse. So I conclude with this brief analysis that the reporting guidelines of the committee do not specifically refer to the precepts of safeguarding at all. It's possible that they could be expanded to include steps that a state party has put in place, for instance, to require non-profit organizations to register. In many countries, we have a non-profit registration system, such as Ethiopia and South Africa. And then it could also require for registration to take place that non-profit organizations must comply with certain safeguarding principles. An example in point relates to South Africa again. The Children's Act establishes a National Child Protection Register, which consists of two parts, and Part B contains the names, or supposed to contain the names, of persons found unsuitable to work with children. This is offenders who have perpetrated abuse against children, who have been through some kind of a procedure, be it a criminal procedure, a disciplinary procedure, whose names are supposed to then appear in Part B of the National Child Protection Register. So amongst other duty bearers, which include schools and police and so forth, any person managing or operating an institution, center, facility, or school must establish whether the name of a person who works with or has access to children at the institution, facility, center, or school appears in Part B of the register. Any person who has access to children does not necessarily only include professionals. It can also include people working on the grounds, people working in the kitchens, people working in the hostels, who may not then work in those settings. In addition, any designated child protection organization, which is a term of art in the Children's Act to allow child protection work to be performed, must also do a screening for all of its staff to ensure that their names do not appear on the register. Proposed amendments to the Children's Act, which are under discussion at the moment, they were drafted last year, will see an insertion into Section 142 of the Act, which will enable the Minister, in this case of Social Development, to prescribe a code of conduct for persons or organizations involved in child protection. This code of conduct will clarify how children are to be treated by non-state staff employed by organizations working with children. And I do have a footnote which details the possible content of the code, which I think meshes very closely with the principles of safeguarding. And then obviously if an organization does not have a code of conduct, then that organization will not be able to be registered. The second subsidiary mechanism that I refer to briefly is the question of dialogue with state parties. The point about the state party reporting process is that it's supposed to lay the basis for a discussion with state parties as to how they can do better, what they've had difficulties and challenges with, and what they should concentrate on improving. Now, in this dialogue, the role of civil society organizations is obviously much less direct. But if the committee was briefed, as has happened in the past, by civil society organizations, by human rights commissions, either orally or in writing, it would equip the committee to engage more meaningfully with state parties in the dialogue process about concerns relating to safeguarding. But we would require that information to be given to us. In response, we could only address our concerns to state parties, but we could say, for instance, that there have been insufficient use of criminal sanctions, or that licensing and registration of NPOs need to be put in place, or that registration of organizations who do not react appropriately to breaches of children's rights should be penalized or delicensed. So the recommendations would flow back to state parties, but they could be informed by information that came from civil society actors. My third subsidiary mechanism, as I've called it, is the question of observer status. Committee practice, as with the African Commission on Human and People's Rights, permits that NGOs and INGOs concerned with children's rights in Africa may apply to the committee for observer status. We have rules for the consideration of such applications, and to date, more than 10 such applications for organizations to have observer status have been granted. Several member organizations of the safeguarding movement have applied for and received observer status before the committee. And I list some of them that I can remember from the fact that I had to consider those applications. SOS, Children's Homes International, Tier Fund, Save the Children, Child Helpline International are some of the examples. And observer status grants certain privileges to a CSO. It allows an organization to attend the opening and closing ceremony, to enable participation at committee meetings, to make statements on issues that concern them, and to request the inclusion of specific issues on the agenda of the committee. So this is really where members of the Safeguarding Alliance could link very directly with the agenda of the committee. The next section deals with the committee's relationship generally with NGOs. And the committee has a very proud history of collaboration with NGOs and INGOs, to the point where we had to change the venue for our last meeting in March because there was not enough place in the room to fit in all the NGOs that had pitched up in Addis Ababa. Significant parts of the committee meetings are in fact open and can be attended by NGOs who also use the opportunity to network with each other. In addition, formally, the CSO Forum, Civil Society Forum, was established as a loose coalition of organizations in 2009, and with one exception has met before every single African Committee of Experts meeting since then. For the most part, those meetings have taken place in Addis Ababa, the CSO Forum meetings, although one was held in Dakar. I think it was this year. And it's convention that at least 2 members of the African Committee of Experts also attend the CSO Forum, listen to the concerns and discussions raised by the CSOs that are present. I think there are more than 100 CSO members of the CSO Forum. And then there's also an opportunity to draft a formal statement and to submit that to the committee at its opening ceremony when the meeting actually starts. The CSO Forum is also a very useful avenue then for the safeguarding constituent members to consider. Then secondly, civil society is also generally consulted by the committee prior to the consideration of a state party report. So at the meeting in March, the CSO report from South Africa was presented by CSOs and considered by the committee prior to the committee drawing up a list of issues, that's what list of issues, LOI, which the state is required to further respond to. Usually the CSO involvement at the pre-session is a coalition event, so we try and encourage organizations to get together and to submit one report to, from the point of view of obviously a very varied selection of CSOs, from health to education to justice to etc., child labor. But that's also an opportunity at country level for members of the safeguarding movement to get involved in facilitating the drafting of the CSO report once it becomes known that a state party has reported. So, for instance, when Lesotho submitted its report a short while ago, I was asked to find CSOs in Lesotho who could get together in a consortium and draw people in to write the CSO report, which has in fact happened. Pardon? Somebody here who's part of that. Oh. So again, opportunity for CSOs to get involved. So proposals for enhancing the response to safeguarding in the regional context within the context of the role of the African Committee of Experts on the Rights of the Child. I propose that there is considerable guidance to be sought in the CRC General Comment number 13 on the right of the child to freedom from all forms of violence, to which all African countries are in any event signatories and are therefore supposed to comply with the general comment itself. So for instance, look at paragraph 49 of this general comment, which requires that in every country, professionals who work directly with children must be required to report instances of violence or risk of violence. We could, as a committee of experts, include in the list of questions that we put to state parties a question relating to the legal framework for the reporting of child abuse and neglect if the state party has failed to elaborate on that in a state party report in sufficient detail. Paragraph 53 talks about the necessity of follow-up. Who has the responsibility for the child and the family from reporting and referral all the way through to follow-up? The aims of any course taken, the details, deadlines for implementation and proposed durations of any interventions, etc., etc. I'm quoting from paragraph 53. That could also be something that we could raise with African governments. Where does the responsibility lie? Paragraph 55 deals with a range of interventions to ensure that violence against children is not met with impunity. For instance, disciplinary or administrative proceedings must be taken against professionals for neglectful or inappropriate behavior in dealing with suspected cases of child maltreatment. Again, in dialogue with state parties, we could establish whether disciplinary and administrative proceedings are in fact utilized when breaches occur. For instance, in relation to South Africa, a conference held recently by the Human Rights Commission, at which I spoke, was cognizant of the fact that although corporal punishment in schools was outlawed in 1996, last year 2 million children were subjected to corporal punishment in South African schools. Obviously, there is no follow-up, and teachers are being allowed to get away with this with impunity. Finally, from the general comment of the CRC committee also is the proposal of a national coordinating framework on violence against children to provide a common frame of reference and a mechanism for communication among government ministries and also state and civil society actors. It can be an initiative that's led simultaneously by both government and communities, but contained in an overall cohesive and coordinated framework. This is paragraph 69. So together with CSO partners, the African Committee of Experts could, in our responses to state parties, champion the development of national coordinating frameworks at country level to ensure improved responses to violence perpetrated upon children and to take account of some of the initiatives being furthered by the safeguarding movement. Finally, and this is really the end of where I am, yes, I want to refer to the desirability for safeguarding issues to surface at the sub-regional level. And here I'm talking about ECOWAS, the East African Community, the EAC, because it's becoming apparent that more and more human rights issues are surfacing at the sub-regional level, including in relation to children, and I refer in particular to the Bujumbura Declaration on Child Rights and Wellbeing in East Africa and the development of a child rights policy for East Africa. So this could be another useful target. We're not supposed to use the word target, somebody said earlier, but this could be another useful target for organizations who are linking with the regional economic communities. So I think that's the last slide. In my conclusion, I think it's important to bear in mind that the vast majority of service providers are, in fact, CSOs and not governments, which creates a little bit of tension when I stand here and talk about the role of the African Committee of Experts, but the duty bearers under the Charter are state parties or governments who are not necessarily the ones delivering services at the coalface. But I have tried to suggest some scope for complementary dialogue on safeguarding and the AU mechanisms, and I would also finally like the audience to bear in mind some of the other campaigns that are very important at the AU level that the committee, of course, is involved in but not driving, and in particular the campaign to end early marriage, which is a very, very high priority of Commissioner Zuma. Thank you.
Thank you. Thank you very much, Julia. I thought that there was incredible amount of food for thought there, and also the beginnings of a campaign. I'm going to now then open the floor for questions or comments on Julia's presentation and the thoughts and proposals that she put to the conference. Yes, David, please.
Thank you very much, Julia. Can I just ask you this about the protection register? What are the criteria for ending up on it, and what's the age limit downwards?
Okay, we'll take another couple of questions, and then Julia can. Dr. Shimelis.
Thank you, Corinne. I would like to build from what Professor Julia said at the end in her conclusions about the role of civil society organizations. Especially Pan-African organizations like the African Child Policy Forum, because I think there is a lot to contribute to the work of the committee, not only in terms of providing evidence when the committee reviews state party reports, but also in terms of developing guidelines, because the committee has got a very expansive mandate, like Professor Julie said, but it has got a very limited capacity. So in other words, each one of us here has a role to play in supporting the committee technically. For instance, we can play a role in pushing governments to ratify the treaty. There are countries that are not yet state parties to the Charter. We can support governments to prepare their state party reports, by, for instance, providing them with evidence, giving them technical support, etc. The African Child Policy Forum, for instance, has been actively involved in, the civil society forums that Professor Julia talked about. We have also developed some guidelines that was later adopted by the committee, and such kinds of interventions are very crucial to the committee. This is my intervention in a nutshell. Yeah.
Thank you. Take another question before. Yeah, Kate, please.
It's a bit of a bugbear of mine that often at conferences on safeguarding and child protection, it seems we hear very little about parental domestic violence and its impact on children. And I'm wondering whether the committee does do anything to encourage states to perform better in their dealings with parental domestic violence, because there's a lot of strong research that says that the impacts on children are worse actually than for direct physical maltreatment and even sexual abuse. There's some very strong research that came out last year on that. So, yeah, is that being taken up?
Okay, so, Julie, do you want to respond to those?
Three very disparate interventions. Regarding the criteria for a name to be included on the National Child Protection Register, this is going to confuse everybody because there's also a sex offender register, but we can get into that outside. But the National Child Protection Register is a finding that you are unsuitable to work with children. That would be based on either a criminal case, or it could actually even be based on a disciplinary finding. It doesn't have to be a criminal court. It could be a civil court that's found a person to be a perpetrator of domestic violence. But we don't have any jurisprudence on that yet, so I can't give you the exact meaning. And I think also that for tribunals to make a finding of unsuitability to work with children is also a challenge. They haven't started doing that yet, but that is actually the criteria, as well as the conviction for a whole range of criminal offences which are specified, like murder and rape and things like that, of a child. As regards the age issue, the Children's Act did not specify a minimum age for inclusion on the register, but that provision, the failure to specify an age, has recently been challenged in the Constitutional Court successfully. Christina, correct? Where's Christina? Yes, successfully challenged on the basis that it did not individualize the inclusion of children's names on the register, which in each case had to be considered in the child's best interest. So there is now de facto a minimum age of 18 following on the finding of the Constitutional Court. As regards Shmelis, I hope you didn't think that I didn't say that the African Committee of Experts has a very good relationship with NGOs, including with the ACPF, and is reliant almost totally for the completion of its work on NGOs and INGOs, including for paying for my flying to Addis, because the AU doesn't have money for us. So, quite frankly, were it not for support by the NGOs, we wouldn't meet ever. Or do anything. And yes, so thank you for that. But I hope my presentation didn't suggest that we were dispensing with NGOs. Contrary to what I was trying to say, that the primary dialogue is vis-a-vis state parties. So we depend on the NGOs to feed us with information in the various ways in which I detailed, so that we can engage in a more detailed way with governments. As regards parental domestic violence, I can't recall if that has surfaced at the committee level in responses to state parties. I have read the South Africa country report, although I'm not part of the deliberations on it. And I know that there is a paragraph somewhere on the usual things, the Domestic Violence Act and the fact that there is legislation in place and so forth. But I don't think that the committee has had a direct focus on that, although we have had a focus on violence against children.
Other questions, comments? Yes, please. Victoria here. You'll get a microphone, Victoria.
Excuse me, I just want to know in terms of well, I consider it a strategic issue, that of identification of children and documentation or citizenship of children. Many of our children are stateless and faceless, and that is a gap in terms of supporting children and safeguarding them in those kind of situations. What does the comment say about that? Thanks.
Other questions, comments? Yes, Noreen, please, at the front. Hurry up with the microphone.
Thank you. Thanks, Professor, for the presentation. Just to find out, should a state that has ratified the charter not be complying, what are some of the remedial actions that the committee has taken?
Anything else before we get Julia to answer that? Oh, yes.
Taylor from Zimbabwe. You're talking of a campaign on early marriage, Prof. There is no thinking that you cannot talk of early marriage with a child. Maybe some other name, but it's rape, it's statutory rape, or you can't talk of even marriage with a child. I think here, as a committee, you need to think around that. How, what name can you give it? But early marriage is like legitimizing something that is not legitimate. Thank you.
Thank you. Sir, I'll just take to the lady here in yellow, and then if you was, then we'll move to Julia for response.
Thank you. I would like to understand, sorry, thank you. My name is Marcia Pinto from Mozambique, Attorney General Office of Mozambique. And I would like to understand more about the list of people not suitable to work with child, because I remember that we have a legislation, for example, for creches. For the creches, we have a number of people not suitable to work with child. For example, any person who have been convicted with any type of crime to child's violence, physical violence, any type, psychological, any type of violence. And I would like to understand more if there is. Thank you.
Thanks, Julia. I'll start with the first question on documentation of children and statelessness. I'm very proud to announce that our second general comment, which we have completed and which is on our website, is on Article 6 of the Charter, and it deals with birth registration, the right to a name and nationality, and with statelessness. We will launch it at some point in the future because we are launching general comment number 1 at this event, but it contains very comprehensive guidance to state parties as to the measures they must take in implementing birth registration systems, which is another very high priority of the African Union, and what measures they must take to prevent statelessness. And so we'll be talking with the UNHCR in the future about how we can take forward the content of the general comment, particularly with civil registration and vital statistics ministers, CSVR, so that we can start implementing the general comment at country level. So this is a high priority of the committee, and I didn't mention earlier that each member of the committee has a specific portfolio. So there is a committee member who has the portfolio of violence against children, and I have the portfolio of birth registration. Then a very useful question that Doreen asked about: if a state does not comply, what remedial actions can be taken? Well, in international human rights law, short of invading a country who doesn't comply, which some nation states seem to do quite regularly, there is no remedial action that can be taken. It's a question of the public censure that can ensue if state parties do not fully commit. The membership of the African Union is such that there is, in fact, a community of states that agree to be bound by the same human rights principles. And so one could imagine that if a state does not comply, there could be some actions taken at the AU level, or at least there's some public censure. And I think I would like to tell a story about the African Child Policy Forum, if Shamelis doesn't mind, about the Africa Child Wellbeing Report that the ACPF has been producing since 2009, which actually contains a statistical list of who's doing better and who's doing worse. And I know for a fact that there are governments that take notice of where they are in the list in that report, because the King of Swaziland called UNICEF at 6 o'clock on a Saturday morning and said, "Why are we coming down so low?" And the UNICEF representative said, "Because you haven't taken any steps to improve children's rights. You haven't ratified this, you haven't written the Children's Act. But by the way, here is the Children's Act." And he signed immediately. It was in 2012. So I think there are other avenues for trying to secure improved state response. The question of child marriage, I quite agree with you, but I would like to just point out to the audience here seated that the minimum age for marriage in South Africa is still 12. Yes. So, so there is much more work to be done before there's a generally accepted principle that no person under 18 can get married. In relation to the question from our colleague from Mozambique, I think it's a very important and very complicated topic that you've raised. I myself have been for 10 years, a huge supporter of the concept of a child protection register, which includes perpetrator names, on the understanding that it would allow for people to be screened. There are also, amongst the child rights activists, people who do not agree with the child protection register, for reasons which are now turning out to be quite true, namely that it diverts a huge amount of resources and capacity to a half-baked list of something like 136 names, which does nobody any good. And furthermore, that it devotes scarce resources to a system of checking up. So you have to apply to see whether X or Y's name is on the register. And if the list is not complete, then what are you getting back anyway? You're getting back a load of rubbish. So the question is whether African countries, and South Africa is, of course, amongst the more developed and wealthy, are in a position to devote resources to an undertaking which seems to be a little bit flawed. So whilst I'm still a fan of a national child protection register, but I think everyone's starting to get a little bit disillusioned.
Okay. Other questions, comments? Okay.
Thank you, Corinne. I don't have a question, but I have an appeal to the conference. I'm really touched about the situation in Nigeria, and I'm wondering what we could do as child protection or child rights defenders gathered here today, whether it wouldn't be befitting for us to come up with a communique, taking advantage of the giant that's sitting here with us today, the African Committee of Experts on Children's Rights, so that they can at least maybe submit a press statement or something that expresses our solidarity on the issues concerning the girls and boys in Nigeria. Thank you.
Yes, please.
My question is more around understanding at what level of priority is this committee dealing with issues of underreporting of sexual offences of children and the commercial sexual exploitation of children as well, because that I think is a huge issue. And to what extent is the committee mandating states or motivating various states to take specific planned actions to improve the number of instances that are reported, so the figures that we're all working from can become more realistic? And also in terms of strengthening reporting mechanisms specifically, because there's a whole chain of stakeholders that are involved there, and is the committee prioritizing these two issues as its position to kind of influence the way that these issues are dealt? And we're constantly thumb-sucking figures and talking about estimates and not knowing how serious some of these issues are.
One, yes. Lady here.
Hi, I've just got a question around the committees, how you ensure as a committee that the child's voice is included in that committee, and how the opinions of children and views of them are put forward. I mean, it might come from the NGOs. I wasn't sure if you did that directly or had a plan to.
Okay. All right, Julie.
Right, the level of priority accorded the question of sexual offences and commercial sexual offences. This has been a high priority of the committee, and it receives attention in country reports, and we've also had a lot of input from CSOs about it. I reckon that the government of South Africa is going to have a hard time in October when they have to deal with the approaches to sexual offending on children, from what I gather, because it's an area of significant weakness. So this is something that has been very, very, and there are quite a few experts in the committee, also from the psychosocial and the and other disciplines. I'm a lawyer, sorry, who routinely ask questions about this. As regards the hearing of the child's voice, we have had in most delegations, in fact, from the very first delegation that presented a country report, which was Egypt, children were part of the delegation of both the CSOs and the government, and were enabled to speak during the committee session and give their own views. Also, we commissioned our partner organizations, the NGOs that we need so badly, to do children's consultations for the selection of the theme day for the Day of the African Child, which gets held every year on 16th of June. And then we chose from amongst the children's suggestions the theme day for this year and, in fact, also for next year. So in some of our initiatives, that's just two that I can recall offhand, we are not directly accessing children's views, although we have children coming to our meetings as well, and we have representatives from the Movement for Working Children in West Africa, and they speak on the same basis as everybody else. But we also have taken outreach steps to make sure that children's voices are heard when we come to determine our own priorities.
Yeah. Okay, yes, please, Carol.
Hi, I'm Carol from Joburg Child Welfare. With the influx of people from all parts of Africa to Johannesburg trying to find some way of getting money, we find that we are having many children who have come with their parents on asylum seekers permits, refugee permits, and sometimes with no permits. The parents sometimes die, they get abandoned, the children get abandoned, or they get abused, and then they come into our care and the parents disappear. We're sitting with probably 100 children. And these children, the Constitution says that we treat every child as a child, no matter what. But when they turn 18, they are no longer a child. Also, if they're on an asylum seeker's permit and it has expired, we've got to renew that permit at 1,500 Rand. We're an NGO, we can't afford that. We need a way that that we can take care of the children and find a way that we can, at 18, get citizenship for them or get them have a naturalization process. Otherwise, we have helped those children to learn about our customs, to learn our languages, to think that they are South African. But at 18, they are illegal immigrants. And that is actually immoral. Can you help us? Because we desperately need help. Also, placing them in foster care, placing them in children's homes is an impossible task. Help.
One last comment. Okay, Julia, do you want to just respond to...
Not really. I was at a meeting at Scalabrini Centre earlier this year where some of the difficulties were discussed, in particular the difficulty that the children have no birth registration systems in their home country, so they aren't citizens of South Africa, they are citizens of another country, but DRC doesn't have any birth registration, etc., which makes it very difficult. But I don't have an answer as to what to do when children turn 18, but I suggest that you link up with other organizations. There was a conference subsequent to that to look at the range of issues involving children in an irregular migrant status or without documentation, so that there's at least a coordinated response. Also to mention that the one of the two children that was brought by the NGOs to Addis Ababa to address the African Committee of Experts was actually a refugee child from Johannesburg. So the matter is before the committee, but as a South African, I cannot be part of the deliberations about the government of South Africa.
Okay, I want to say thank you very much, Julia, for a really engaging session. And I want us, please, just to take away the thoughts and conclusions that Julia made, that there is a lot of work that's taking place, but there are gaps that Julia identified, particularly around how safeguarding is referred to or included within the work of the committee at the moment. And some of that is our responsibility as organisations working on this issue to engage with the committee and engage with governments. And I think that set us up very nicely in concluding today, because tomorrow what we're going to focus the day on is looking at what governments need to be doing with safeguarding. Okay, what do they need to be putting in place to ensure that organisations and institutions and professionals who are working or impacting on children do no harm. And in the afternoon we'll be looking at what the aid and development community has already done, but what more needs to happen on that. So let's give Julia a hand. Thank you very much. And then please take a tour of the stands downstairs, and if you haven't already gone round them, and then join us at 6 o'clock, please, in the garden for the reception.
Before everybody gets up, I'd just like to make a request in relation to the stands. I'm running one of the stands downstairs, remembering the future, and I have some resources on my stand which were for display only, which I failed to mark. But somebody has taken them away. So if you have, I would ask, please bring them back. One is a book, Those Are My Private Parts, which is a blue book, the kids drawing on the front, and the other one is a green handbook, a parent handbook on the table. And I understand Plan has had a similar into the capitalism of their resources. So if anybody has
if you've taken resources from the stands, please take them back to the stands and ask permission at the end of the conference whether you can take them then.